Have you ever wondered what's covered under intellectual property? What do you do if someone copies your hard work? And what recourse do you have if someone copies your intellectual property? So today we're going to be diving into all of these topics. My name is Zara Watson-Young, and I'm the co-founder of Watson-Young Law. And I'm here today with our co-founder, Sean Young. And we're going to first start talking about what is covered under intellectual property. So intellectual property, to keep it very simple, is anything that you have created, right? It's very broad. And the law basically gives you, there are three forms of intellectual property. The first, we're going to talk about trademark law. And trademark law covers any of your brand identifiers. So anything that identifies your brand. So think of your logo, your business name, any slogans that you use in your business, catchphrases. You can even protect product packaging because it identifies your brand. So think of the Christian Louboutin shoes or the famous Essie nail polish bottle. It's curved bottle. Anything that identifies your brand is protected under trademark law. And then now copyright law covers any of your what we call content. So anything that you have put in what's called a tangible medium. So anything that is pen to paper, if you're an artist creating artwork, so any of your paintings, if you're a photographer, any of the content that you have created is protected under copyright law. And then we have patent law.
Yeah, so patents protect inventions essentially. So it'll be an invention needs to be a novel, so it has to be new, a new invention, and it has to have utility. So it has to actually function and do something. So that's what's covered under patents. When you think of patents, you think of inventions, you think of, maybe it's a new software algorithm that does something, or it's a new electric vehicle that maybe are component of an electric vehicle. And so these are all inventions that are covered under patent law. And it has to, again, have two elements. It has to be a new and novel invention, and it has to serve some form of utility. So it has to do something. And then last, we have trade secrets, and trade secrets is really going to be things that are protected because they are maybe an internal process or a way about doing so. Like think of like a secret recipe of sorts. And while you don't file for a trade secret, if you can prove that it is something that is secret and unique to your business and it's proprietary and your business uses it in commerce and it's what makes your business unique, then it is considered a trade secret. And think of trade secrets really in the employee-employer context. You have an employee, you've taught them your proprietary way of doing things. This is what makes, let's say you're a military company, you have a secret way of building these weapons, or think about Coca-Cola. You have a secret recipe that you use that makes you very different for your competitors. You're bringing in your employees, and now your employee is leaving to go to the competition, and with him, he's trying to bring these secret proprietary methods to this competitor. And so you would come in, you would essentially ask for an injunction from the court to stop them from doing that, and you would allege that this is a trade secret, and really it's unique to your business, and it's what makes your business function, and therefore you have rights to these trade secrets, and you can stop them from doing that.
Yeah, intellectual property is such a fascinating area because it's really you're protecting the ideas. You're protecting the ideas of the mind. And there's a saying, right? Like your wealth comes from your ideas, right? So I feel so fortunate to work with Sean to help other business owners protect their wealth and to protect their inventions, their creations. And unfortunately, we are living in an age, the digital age, where a lot of these ideas and, what you're putting out into the market is being copied, right? The internet is a wild, wild west, as we like to say. And because of that, it's so important for you to put, protections in place as early and as soon as possible to make sure that, again, what you're putting out there is protected. Because literally all it takes is someone just, going on your Instagram or your TikTok, any social media platform, seeing what you're creating and, replicating that, right? And in copyright law, again, copyright equals content, I like to say. Basically, there's a standard of what's called substantially similar, right? There are degrees of how much someone can copy you. So someone can copy you a lot or a little, and it's really going to be up to you as the inventor and the creator of that work to really see, okay, like how much have they taken basically from what I've created. So it's really important, again, to make sure that you're putting these protections, make sure that you're registering your trademark, registering your copyright, registering your patent with the proper governmental agencies, so that if that comes, actually not if, when, because as you're growing, it will happen, because you're going to be putting yourself out there, and with more visibility, the more at risk you put your brand. You want to make sure that you have these protections in place.
Right. I think people say imitation is a form of flattery. Well, for a lot of our business owners, imitation equals infringement, right? You're infringing on their rights. And unfortunately, imitation and intellectual property theft is nothing new. The foundations of this country, the Constitution, actually copyright law is written into the Constitution. So we're talking about from 1776. And part of the rationale why we have intellectual property laws in this country is because we want to make it fair to business owners that are putting this hard work, energy, effort into bringing these products to the marketplace. We want to make it fair that they have ownership over these concepts, these ideas, these content, because we want to incentivize them to continue to do business. Otherwise, people don't. Why would you want to go into business if someone can just take your idea, claim it as their own, and then essentially profit off of your hard work and your innovation? So these are laws and frameworks that are designed to protect you. And although the internet is the wild, wild west, there are ways that you can protect your business. Like you said, registering your copyright is the first step. You want to make sure that your work is registered, so it's clear and expressed that you own this content. And so anyone coming after you that are trying to replicate what you're doing, you can then send them a cease and desist and a demand letter, essentially asking them to stop. If you have a new novel invention, you want to patent it. If you have branding that's really made you've built your reputation, your branding is everything, then you want to make sure that you have a trademark in place, and good contracts too. Contracts can help, having intellectual property provisions in contracts. If you're buying this course and you've opted in, now you've signed this contract expressly by checking the box that you are not going to use my course content as your own and replicate it. And so you want to have these in place so that if it does happen, it's clear that you can go after them.
So let's talk about what to do, right, if it does happen to you. So there are so many different variations or scenarios that can come into play. But let's say you are a course creator, you've put so much time into creating your course, and someone purchases your course, right? We've had this happen to clients in the past where people have purchased their course and basically tried to make small tweaks to the course or nothing at all, right? We've had situations where people have not made any changes, and they've just basically replicated the product and started copying it. So essentially what you want to first do is take proof, right? You can take screenshots of everything, right? We always appreciate an organized zip file. So if you could basically organize everything into a folder, take screenshots of whatever you've discovered, whether it is on social media or the actual course content. You want to take pictures of that, save it in a folder. Any correspondence, some of our clients have basically reached out to the other business owner and have had communication. So any of that correspondence, you want to save that for us in a file. And essentially from there, we always recommend reaching out to a lawyer first, because sometimes if you are reaching out to someone who has infringed on, let's say, a trademark or a copyright, whatever it is, they could have been using it before you, right? Just to give you an example. So you always, always, always want to reach out to a licensed attorney to make sure that you are not opening up a can of worms accidentally. Because if they were using, let's say, a trademark before you, they will have what's called common law rights, and they can threaten to cancel your trademark. Okay, meaning that they were using it first. So you always want to be careful and cautious of how you're reaching out to someone and working with a lawyer. So basically, reach out to your lawyer, and that lawyer will basically do digging for you. They'll see, okay, were they using it first, or were you using it first, right? Of course, the goal is for you to be using it first, right, so that you will have the authority and the leverage to reach out to the individual and have them take everything down and to stop their infringement. So in that circumstance, you want to always work with a lawyer. But if going back to that course situation, you have all your proof ready and you send that proof to a lawyer, that lawyer will again do some more research to see what's going on, making sure that you have that ultimate leverage to reach out to them. So whether it is trademark infringement or copyright infringement, where someone is copying your course content or any other content, you want to make sure that you have leverage.
Right. And it's so important to make sure that you're doing the proper due diligence before you reach out to the opposing side. Because again, you don't want them to then turn around and say, hey, by the way, I'm not infringing. You're actually infringing. And that, again, will not be good for you, because I'm sure that you didn't imagine it transpiring that way. So hiring an attorney that will go ahead and do the due diligence to ensure that you actually have superior rights to this individual that may be copying your brand, your work, is essential to avoid that situation.
Yeah, and I also want to highlight how we understand how, overwhelming it might feel or scary. And of course, stressful, right? Because you're running your business and you have now this to deal with. But, there are lawyers out there who will take care of the issue for you. So you want to make sure that you're choosing a lawyer who, of course, has experience and really cares, because at the end of the day, they are fighting this on your behalf. So you want a lawyer who is, of course, passionate about what they're doing and just willing to fight for you, who believes in your case and your cause.
And specializes in intellectual property law, that knows these issues in and out and can really advise you on the right course of action. Unfortunately, there are some generalist attorneys out there, and while they can handle basic matters, unfortunately, because of intellectual property and the nuances, it's important. That's a key consideration to really hire a specialist. Similar to if you were going to go to your generalist identifies maybe there's a problem, but he then sends you to a specialist because this doctor maybe specializes in heart conditions. So it's the same kind of concept when you're looking for an attorney to handle some of these intellectual property issues.
And also the strategy involved, like you just mentioned, the importance of working with a specialist. It's really important because that specialist attorney will really know the strategy, because oftentimes, believe it or not, a lot of intellectual property will come into play, right? So you might think you're coming to us for just a copyright issue, but there is also a trademark issue, right? And we may have to cancel someone's trademark, and there's timing involved, and again, a lot of strategy involved. So Sean and I joke around how it's almost like performing surgery, right? There's different pieces that we have to put together before we can, even reach out to someone and ultimately solve the case. So you want to make sure that you're working with a specialist for sure. And then in terms of, again, just the different forms of intellectual property, really understanding that, because as your business is growing, you may start out with just a trademark, but then you need to copyright, right? If you are a course creator, for example, you're maybe a coach, just to give an example, you may just start out with a trademark, but as your business is growing and as you are expanding into different product areas, you will need other areas of law, right? You will need a copyright registration. You will need maybe a patent. Maybe you invented a whole new way or a whole new method of doing something, and you may need a patent. So really understanding trademark, copyright, and patent law, how they all, intertwine, is very important as well.
That's right. So for copyright and content, the person that is filming the copyright and fixing it on what's called a tangible medium owns the actual copyright. So let's say you hire a photographer and you have a photo shoot. A lot of people would say, well, I hired the photographer, so I own all those pictures, or I hired a videographer, so I own all these videos. No, that's not the case. The person that owns the video and the photos is the videographer and the photographer, because they're the ones taking the shots and the images. So it's important when you are doing photo shoots or filming your content, the person that is actually filming, that owns the equipment, that is performing that activity, in the agreement that they're actually handing over that copyright to you, and to avoid any confusion. And there are a lot of cases like that where you find celebrities, they'll get pictures taken of them, and then they'll post it on their Instagram, and then they'll get hit with a cease and desist, right? But their argument is essentially, well, it's a photo of me, I own it, right? No, that's not the case. The videographer and the photographer own it because they fixed it on that tangible medium, right? They took that image. And so it's important to bear in mind, and it's kind of where contracts and copyright, they come together, right? So you want to make sure in your contract you're addressing that issue from the outset, that yes, you are hired to do this job, and in this job, when you do the photos, that you're assigning those rights to me.
Yeah, just like Sean said, it's called an assignment. So basically, if you hire a photographer, as an example, if you hire the photographer, once they take that image, they will then assign the copyright to you once you've fulfilled your payment, right? Once you've made that final payment, you will then become the ultimate owner of that copyright. So again, going back to the beginning, it's so important to understand these differences about who owns what. A lot of coaches, they will bring on what's called a guest expert. And sometimes that coach will want that guest expert, their series or their recording to be housed on their platform. Kajabi is a big one, right? So they'll want Kajabi, that platform, to basically house that guest expert's content, right? So the question becomes, who owns the content, for how long? Can I use this in perpetuity? And all of that should be ironed out in a contract. So in that contract, you and, the coach, let's say you're the guest expert, you and the coach will basically come to some sort of agreement as to who owns the intellectual property, who owns the recording. And it'll be up to you whether you want it to be maybe for a quarter, maybe for a year or longer. You and the coach will basically work that out. And if you want it to be in perpetuity and forever, you and the coach, again, will work that out in the agreement. You may want to provide that content for a fee, or maybe license it. That's another option. You can license your content to, a creator, and they'll be able to disseminate your content, with your permission, of course, in that contract. So a lot of it comes down to the contract.
Right. And why don't you touch on social media? When someone posts a video on social media, they might own the video, but it's really Meta's platform. So really there are certain considerations in play.
Yep. Sean basically just said it. So you have to be mindful that when you're putting your content onto Meta, you are basically giving Meta that right. So you're basically transferring your copyright to Meta, and they essentially own your content. It's actually in their terms and conditions and privacy policy. All that is laid out. Yes, of course, if someone is basically infringing on your content and you're posting on Instagram or you're posting on TikTok, that content, yes, it is yours, and you do have the right to basically go after, another business or another individual who's copying your content. But essentially, it is technically Meta's. So if you have any questions about what is a trademark, what copyrights do I need a patent, you can always book our trademark strategy sessions. We can talk about any of these areas of intellectual property law and give you that clarity and peace of mind that you're looking for.
Please click the like and subscribe button.